Hello everyone, welcome back. And if you're watching this video today, it's Sunday and we're in the office working and helping a number of different clients. So in this video, I'm going to talk to you about the Marchman Act. I was asked by somebody who works actually in the behavioral health space, somebody I have enormous respect for, who over the years has helped a bunch of people and has been really a bit of a mentor for me. And she said to me, there's a lot of confusion about the Marchman Act. There's some changes that happened July the 1st of 2024. Would you do a video, sort of a 10,000 foot overview of what the Marchman Act is and how it works? So of course I'm happy to share that with you. I love talking about what we do and how we help to save families. So here is the Marchman Act, and you're welcome to go and check it out. It's chapter 397 of the Florida statutes. You just Google Florida Statute 397, it'll bring up the Marchman Act. But let me sort of tell you how it works as sort of a general rule. So what is the Marchman Act? The Marchman Act is a statute that allows you to put your loved one into treatment where there's a primary substance use disorder and potentially co-occurring mental illness, which these days is nearly always the case, for periods of up to 90 days. Not for 90 days, but up to 90 days, okay? So that means there's a ceiling here, and in between here, the facility has some discretion, meaning they could only hold them 70 days or 80 days. I'll tell you from a practical experience, that never happens, because by the time the case gets to us, this person needs 90 days and then some, and I'll talk to you about how you can renew this thing in a little bit. But it's up to 90 days where there's a primary substance use disorder. Now, if it's an adult, that we're looking to put into treatment, then anybody with direct personal knowledge, one person can be the petitioner. If it's a minor, and we don't see a lot of children who have these issues, not that they don't have these issues, but where the parents are not able to handle it on their own, then it's got to be the parent or the legal guardian who is the petitioner. So that's the Marchman Act, putting somebody into treatment for up to 90 days. Now, there are two steps to this, and this is where some of the confusion tends to happen. And even though there's two steps to it, the request, the actual filing is just a one-shot deal. Before July the 1st of 24, it was two separate filings. Now it's one, only one filing. So the first part of the Marchman Act is a period of assessment. And what that means is that they have to be assessed by somebody who is considered under the Marchman Act a, quote, qualified professional. Could be a licensed clinical social worker, mental health counselor, certified addiction professional, psychiatrist, psychologist, a doctor, somebody who the statute says is a qualified professional and can do the assessment. That assessment is required by the court in order to order somebody into treatment. No assessment, no treatment. That's just the way it works. And the idea behind that is that we want somebody who is qualified to come into court and tell the judge or the general magistrate who is hearing the case, this person needs to go to treatment. They're a danger to themselves. They have no ability to appreciate their need for services. And Your Honor, if you don't order it, they're not going to go into treatment. And of course, we all know what happens when somebody who needs treatment doesn't go into treatment. And I've talked about that in other videos, so I'm not going to go there today, but you understand where I'm going with this. So that assessment period can be initiated one of two ways. I told you this was a little confusing, right? Either it's done on an emergency basis, which means no hearing. It means that the court is going to review the petition that we file. Remember, it's only one petition, not two anymore. And if the court thinks that it meets certain criteria, if there's an emergency, meaning we don't have time for a hearing or the appointment of counsel, the court's going to issue an order ordering the police to go and get that person, pick them up off the streets. And if they're on the streets, we're going to do that for the police, because the cops are not going to be able to find this person, which is why I have just an amazing investigator with a team of former law enforcement officers who can help us with this. They're going to pick that person up and take them to a receiving facility, which is in the court order. Now, once the period of assessment's over, at the same time that we file the petition for treatment, which includes the request for assessment, the court's going to set a treatment services hearing. So now we're looking to take their liberty away, right, in theory. So even though this is civil in nature, it's not criminal, some of the criminal constitutional rights apply, right? The right to counsel, the right to a hearing, the right to confront witnesses against them, The right to remain silent all applies in this civil Marchman Act proceeding because we're looking to potentially take their liberty away. In other words, we're going to make them go to treatment. They can't go home, they got to go to treatment. So there's going to be a hearing, okay? Now, one of two things can happen at that hearing. They agree to go to treatment. Fantastic, okay? It's a 5-minute hearing. The judge or the general magistrate says, you know, dear sir, dear madam, you understand I'm ordering you into treatment. If you don't go, or you're non-compliant, or you leave, well, we're going to have a different conversation, and it's not going to be about treatment. It's going to be about how much time I could potentially put you in the county jail for, or some other sanction. So if it's agreed to, fantastic. It's a 5-minute hearing. If it's not agreed to, then there's going to be like a small trial in front of the judge or the general magistrate. And if we're petitioner's counsel, we have to meet our burden of proof. We have to prove by clear and convincing evidence that the person, meets criteria under the Marchman Act, that they need to be sent to treatment under a court order. Providing all our ducks in a row, we typically win those cases. So assessment, treatment. Now, as I told you, the max under the Marchman Act is up to 90 days. Well, most of our Marchman Act cases go anywhere between 90 days and 180 days, 3 to 6 months. And why is that? Well, because we know from experience that if you can keep somebody in recovery for up to a year, then they have a better than not chance of remaining in recovery for the rest of their lives, right? And so I'm not telling you got to hire me for a year or even put them in treatment for a year, but if you can get them into treatment for 3, even better, 6 months, then they work an aftercare program like 12 steps, getting a sponsor, going to meetings, continue with some kind of outpatient therapy, and you get them to 1 year, that gives them a great chance, right? Now they develop the skill set they need to maintain recovery. Their brain gets a chance to heal, their body gets a chance to heal, and now we're dealing with a different kind of individual. And I will tell you that it's an incredibly rewarding experience to see that when we're dealing with an individual. And also their family needs time to heal. And I can tell you, having spoken to, at this point, thousands and thousands of families, you need time to heal. You really do. I bet you haven't had a good night's sleep in a long time. I bet it's causing tremendous stress in the family, at work. I mean, just devastating. That's why they call it a family disease. It destroys the family unit. So that is the sort of Marchman Act, right? 90 days. Then we can petition for an extension. Ask for another 90 days. Now, I can tell you, I've had somebody in treatment. I had one young man who came in from another state. I had him under the Marchman Act for 2 years. Every 90 days, I went back into court and said, we need a renewal, we need a renewal, we need a renewal. And we were getting it. So that's why I'm saying our average Marchman Act goes 3 to 6 months, because you can extend it. So that is the 10,000-foot general overview of the Marchman Act. A tremendous tool, but it has its limitations. And tomorrow, I'm going to give you a 10,000-foot overview of the guardianship process, which is a very unique way we handle some of these cases. And I'm going to give credit to my wife, who's also my law partner, because she's the guru of guardianship, okay? She's the one that came up with the brilliant idea of using guardianship, which is traditionally for elderly people, for these kinds of cases. And tomorrow I'm going to talk to you all about that. So that is the Marchman Act. Thank you for tuning in. See you tomorrow. Bye-bye.